Thank you, James. All right. My name is Ernie Garcia, and I'm going to talk a little bit about eviction today. I don't know how many of you are active or prospective landlords, but a show of hands, how many of you are active or prospective landlords? Very good. I strongly believe that eviction makes better tenants. And what I mean by that is that our tenants operate on a different basis than our landlords do. The goal of the tenant is to have a place to live, but the goal of the landlord is to make money. Now, the way that the landlord makes money is by supplying a place to live. But if the landlord is doing their part and supplying that place, but the tenant's not doing one of their jobs, which is to pay the rent, the goal breaks down for the landlord. It's still intact for the tenant because the place has not been removed. So really, one of the motivations to get the tenant to comply with that agreement is this concept of eviction, which is an ugly word. It's an ugly thing when it's carried out, and I've seen it devolve into all sorts of mess. But it's one of those things that we use as a tool to accomplish our goal. It's been said that good fences make good neighbors. Why is that? Why is it that good fences make good neighbors? Anybody?
You said boundaries? Said
fences.
Yeah, but you said boundaries, like everybody knows.
You said boundaries.
Yeah,
okay, that's
knows
good.
Their role in the transaction or
okay.
in the relationship.
What else?
Privacy.
Privacy, yeah. What I've found is that when there is clarity between parties, it's the easiest way to get what you want. When there is no fence, your kids aren't going to know precisely when they're on the wrong side of the property line. Your dog certainly isn't going to know when they're on the right side of the property line. And sometimes this causes a problem. It's not always a problem. Sometimes there's friendliness between neighbors and we'll just walk across and do whatever. But sometimes things go wrong, and we can always expect things to go wrong. Having that fence there establishes a parameter, and it gives us an ability to enforce where too much has been accomplished, right? If they've gone too far across, we can now enforce that. And that's what eviction is about. Eviction is the consequence for going too far. Your lease is that fence line. It is the boundary. And when your tenant has crossed it, eviction is the only thing that's going to make them stay on the other side, right? Most people are pretty good, that they're not intending to do wrong. But we have to be out, not for the intentional wrong, even the unintended wrong, right? Because even an unintended wrong can cause a landlord harm, and eviction is the way we protect against it. A little bit about myself. My office is on the South Loop near NRG Stadium. I've been in practice for about 13 years. And if you want to contact me, I strongly encourage you to snap a picture of this beautiful man here. Here's my website, my phone number, and the best way to reach me is always through email. Again, even if you just have a question, so many times we get people who just say, hey, I got this thing. Could you help me? Or can you put me in front of somebody who can? Or perhaps just kind of nudge me in the right direction. I have absolutely no problem helping people out. Now, if your situation is more complicated and it might warrant, say, a 30-minute consultation, that's available too. But we sometimes get ourselves in trouble because we jump and then hope there's a net down there to catch us. That's not always the case. So before you jump, if you're unsure if there's a net down there, shoot us an email, give us a call, and maybe there's something we can do to prevent some accident. Okay, so if you are a landlord, I want you to consider eviction in a different way. And I want you to consider it in all aspects of your leasing journey. It should be on the forefront of your mind, beginning, middle, and end. You should have a plan where eviction makes sense, where eviction is part of your calculus. Too many people are so afraid of eviction that they don't even like saying the word. They don't like thinking about it. They're like, no, I know it's been 5 months since I've gotten rent, but I just, it's so hard for me to even, they're having such a hard time. Things are so bad for them. I'm just gonna wait 1 more month. And that is an improper way to, number one, make money. That's a really good way to lose money. And it's an improper way to consider our tenants. Remember, this is an agreement between two parties. They agree to pay and you agree to give them a habitable residence, right? And if you're continuing to do your part and they can't do theirs, that breach is them crashing right through your fence, right? And if your neighbor did that, you would say, hey, your Chevy Malibu just ran right through the fence. Can you take care of that? Right? We don't sit passively when we see the physical breach, but somehow we're much more passive when there is a less physical breach of our lease that causes just as much, if not more, economic damage. So beginning, middle, and end of your lease, you need to be thinking about eviction and the role that it plays. What steps are you taking to prevent eviction? This is if you already anticipate that evictions happen, because newsflash, they happen every day. There are thousands of evictions going on every month across the state of Texas. In Houston alone, in Harris County, every single day, there are 16 justice courts in Harris County alone. 8 precincts, 2 courts per precinct, and their eviction dockets every single week are full. Evictions happen. They're going to continue to happen. And if you use them properly, they're going to make better tenants. I promise I'm going to explain that a little later. But what about in the middle? How do you move past a bad fitting tenant? You have to have a plan in place, and if eviction is that mechanism, I'm telling you, sooner is always better than later. Sooner is better than later. I'm going to talk to you about strategies that you can employ to make sure your losses are diminished. You may not even experience loss, definitely not to a great degree, if you're using eviction the way it is intended to work. Delay is part of it. There's no such thing as instantaneous recovery of possession unless that tenant says, here are the keys, I'm gone. The court is not instant. There's no automatic hammer that goes down. You walk in and you get your property back. That doesn't happen. And because of that, any delay you give only harms you. It only harms you. Now, when we get to the end of a tenancy, how do you make the most of a failed tenancy? We're going to talk about how you can actually put yourself back in a pretty good position even when things have not gone well with your particular tenant. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. It's counterintuitive for me to even say this. I'm probably better off editing this right out of my talk because I make money on evictions. When things go badly and my phone rings, people sign up and people pay me money to deal with problems. But I'll tell you this, I still preach this because I believe in it strongly. And if I can help landlords get to that point, then you guys are better off. And if you guys are better off, then you're making more money and you're getting better tenants, and you'll come to me for other things. Maybe less terrible things than eviction, right? Maybe you'll come to me about expanding your businesses. Maybe you'll come to me and you want to talk about building an LLC or structuring your company in a way that makes more money. Maybe you need to revamp your lease, or you need to talk about forms or other things that we can construct for you that are not about recovering from loss, but they're about growing your business and making more money. So I don't mind, showing you how to prevent some of the uglier stuff. I think it's important for you to learn that, yes, eviction is a path to success, but it's not the only one. It's not the only one. It's certainly not the cleanest one. I want to talk about using the threat of an eviction before things ever get filed. This is an important key for you as you build your landlording practice. Some of you are pros at this, but I'm going to cover this for those of you who maybe have gaps in your approach. You can stop so many evictions before that lease is ever signed. I don't know how many times I've talked to clients who stopped at I want a house, I've got a deposit, here is a lease, here are the keys, let's get going. If you don't have supreme screening, if you don't have any screening right here, you are already losing money, guaranteed. If you're not screening tenants, if you're not checking backgrounds, the big four, credit, rental history, criminal history, and employment. If you are not checking these four, at least one of them, but if you're checking none of them, you are already losing money. We know that the best indication of future behavior is what? Past behavior. And if there's a record of failure and loss and debt and crime, you can expect those things in the future. You need to do some minimal screening. There are companies online that'll do it for you. You could hire a property manager to do it for you. But if you're doing none, you're harming yourself. Get your screening done. Have a great lease. There are lots of good leases out there. How many of you use the Texas Realtors or the Texas Association of Realtors lease? Anybody here? We got a few. Good, good. That's a great lease. Texas Apartment Association also has an excellent lease. We draft leases for people. There are other privately drafted leases that exist out there. But if you don't have a well-crafted lease, you can't expect to make money. There are certain provisions in the Texas Property Code that state unequivocally, if this language is not in your lease, you cannot enforce it as it pertains to, for example, repairs or security deposits. And if you're missing certain language and your tenant knows about it, they can preemptively sue you if things get a little hairy, right? Sometimes our tenants and us, we are not on the same page with a given repair request or some modification that they're asking for. And they say, well, I know that your lease is technically in violation because of X, Y, and Z. And if your tenant knows more about landlord-tenant law than you do, problem. Your lease should be, and there's no such thing as a perfect lease. There's no such thing as a rock-solid, unimpeachable lease. But the better lease you have, the likelier you are to be protected. If your lease is one page, I can tell you right now, it is insufficient. Explain default procedures. I like to tell landlords all the time, before you ever hand over the keys, if your tenant doesn't know what your expectations are of them, you have already set yourself up for failure. You want your tenant to know unequivocally what you absolutely expect of them, that you absolutely expect rent to be paid on time, every time. Problems with the bank, problems with payroll, medical emergencies are not valid reasons for delay in payment. It'll always be met with some kind of notice. You have to have a plan for default every time, whether it's a dog bite, whether it's a late payment, whether it's a broken window. You have to have a procedure in place when default happens, because I guarantee you default will happen. And if you sit passively While default happens, it'll happen again and again and again. And then you're going to come talk to me 15 defaults in and say, Ernie, I'm pulling my hair out. But you're coming to me and you're saying, Ernie, I don't know how to deal with this. Well, you deal with it before the lease starts, and you inform your tenant before anything starts how you're going to deal with defaults. And if you don't have a plan yet, light bulb, get a plan. How long am I going to wait before I give my tenant a notice to vacate? 6 months doesn't sound like a good idea. It should be less than that. My suggestion is 7 days. If you're going longer than 7 days before there's a notice to vacate delivered to your tenant for non-payment of rent, you are losing money. We're going to talk about why in the next segment, but 7 days is my recommendation. Now, some people are like, 7 days? That's terrible. I'm not a beast. I'm not a horrible person. There's nothing beastly about asking your tenants to abide by their own commitment. 7 days. Have great house rules. We do not all own the same piece of property. Our property does not have the same needs. Some people have swimming pools. Some people have an upstairs. Some people's houses were built before 1978. There are different needs for different pieces of property, and there are different uses that have to occur because of the way your property is set up. Now, there are certain house rules that kind of go without saying. You want to be clean. You want to report, breaks and things like that. You almost reiterate stuff that should already be in your lease, but there are certain specific things that you should mention that you just don't tolerate. For example, no loud parties after, say, 11 p.m. Why would this be important? Well, you got neighbors to think about. You've got potentially police. You've got the homeowners association. And you may just want to enforce a rule like this because, truth be told, if someone is habitually having a loud party after 11 a.m., you want the ability to get rid of somebody like this. Or at least, again, notice of default, notice of default, notice of default, to set up potentially an eviction. But house rules are the way that, again, your tenant understands your expectations of them. You may, for example, say, I want the grass watered every week in this way. And it's a house rule, right? Your lease probably talks about regular maintenance. You want them to maintain the grass, keep it in a healthy way, properly maintained. So these are kind of nebulous terms. But if you specifically say, I want this done this way, it becomes enforceable. Because in your mind, you say, well, this guy just doesn't get it. I told him to maintain the yard. And maybe that in his mind means water it once a month. But in your mind, it means something specifically different. Be specific. Have it delineated exactly the way you want it to look, and things are going to go much better. So with rent, people get themselves in trouble a lot with rent because they do not keep a clean ledger. Who understands what I mean by this statement? What does it mean to have a clean ledger, ma'am? Every single payment and expense is logged, but not just that. And that's absolutely necessary. There's also a strategy in the way that payment is applied. So logging it is step one. Applying it in the proper way is step two. I like to describe it with the image of a graduated cylinder. Anybody remember in high school chemistry, the graduated cylinder, right? That long glass tube with the little lines on it. You never saw your chemistry teacher pour blue liquid into that thing, and it went to a certain level, and then they waited and talked for a bit, and they poured a little more blue liquid, and somehow left a gap. But the water rose from another level. And then they talked a little bit longer, and then they poured a little more, and then there was another gap. You know why that doesn't happen? Why there aren't gaps, even though there are gaps in time? Why doesn't that happen? Why are there no gaps in a graduated cylinder? Gravity! It pulls it all the way down, all the way to the bottom. But somehow there are gaps in our ledgers. I've seen this happen because I have landlords bring ledgers to me all the time and say, well, I got a payment in October of last year, and they didn't pay their late fees, but then I got another payment in November, and then there was a broken window that I had to go and fix. They never paid me for that. I got a payment in December, and then I got a payment in February, but I didn't get anything for January. Mr. Garcia, can you help me? And part of me is thinking, well, the first thing I'm going to talk to you about are these gaps. You've got payment and then subsequent payment and then subsequent payment and subsequent payment, but you have gaps where there are fees that have not been wiped off your ledger. Why are these fees still there? Well, he didn't give me any money for them. Yes, he did. Your lease probably, I don't know if you know this, but your lease probably has what's called an application of funds clause. And this application of funds clause says, I can apply any payment you give me to any fee you owe me at my discretion. Now, the person who's leaving gaps is using their discretion and saying, I don't care, it's fine, I'm cool. But the better landlord is taking the first payment where there's a gap and saying, boop, no more gap, but now you owe a little bit of rent. Notice to vacate for non-payment, or notice of default. And then your tenant comes to you and says, whoa, wait, gee, I paid the rent. You did, but you also paid last month's late fee, which I just got off my ledger. Whoo, that feels good. But you still owe rent. And they may, huff and puff, but you are 100% right if your lease has an application of funds clause. And the following month, when they didn't pay, but they paid the month after, they did not pay February's rent. They paid January's rent and probably previous month's fees. Make sure that your ledger, like a graduated cylinder, fills old debt first. If your lease has an application of funds clause, you must keep not just track of everything that comes in, which is absolutely important, but you must apply payment in a way that keeps your ledger clear of gaps. No gaps. Enforce late fees. This one feels harsh to some people because they're like, well, I'll let them slide. It's okay. It's not a big deal. If it's not a big deal, it shouldn't be in your lease. If it's not important enough to enforce, just scratch it out. Just white it right out. Because if it's in the lease, it should be there because it's important to you, and if it's important to you, it should be enforced. I guarantee you that that tenant who constantly pays the late fees can pay more rent. If every month they're paying, like, well, I got this, well, you have undercharged for rent. At lease renewal, you're jumping up because they can obviously afford it. The late fee should be a prohibitive consequence to late payment. If it doesn't prohibit late payment, again, you're probably not charging enough. You are statutorily limited based on the kind of property to 10 or 12% for a late fee. It's possible to exceed it, but that's complicated, and so I like going with the statutory limits when I talk about this. Just like the 7-day rule, you should collect your full amount of late fee by day 7. 100% full amount. Based on state law, who knows? The first day you can collect a late fee payment from your tenant. Anybody know? It's the 4th. State law says if they have not paid by the 3rd day, and your lease may specifically say they have not paid by the 3rd day, then it doesn't say it explicitly, but the implication is on day 4 or later of the month, you can collect a late fee, which means day 4, 5, 6, and 7, collect the maximum. That's what I always, if you're collecting 12% because you have a single family home, 3%, 3%, 3%, 3%. If your rent is $1,000, what's 3% of 1,000? $30? 30, 60, 90, 120. Collect it all in the first 7 days. Because if you're doing 25 and then 10 and 10 and 10 and 10 and 10 and 10 and 10, and 10, $10 is not prohibitive, right? $10 is 1%. It just doesn't prohibit it. And it takes a long time before you can collect the maximum. You want to hit them with the maximum as quickly as possible so that it stings a little bit. If it's a $2,000 fee, then we're talking about $60 and $60 and $60 and $60. And maybe $240 is a more impactful thing within that first week. They're likely to not do it again. But if you've got a $200 rent and you're collecting $50 in the first one and then $10 each additional day, that strategy doesn't make sense. Collect it all within the first 7 days. Day 4, right? Day 4, 5, 6, and 7, collect the maximum. Send notices. Don't be afraid to contact your client and say, that goes beyond my expectation. You are crossing the fence. You did it again. Please fix this. Do it in writing. If you're just calling up and say, hey, by the way, I noticed that rent was late. Can you yada, 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 yada? Yes, that might be effective in reminding them, but why should you have to remind your tenant to pay their rent? They didn't forget. I promise you that. It's not a new thing. So yeah, you can call them, and that might be effective, but the best thing for you to do is send written notice. And we'll get to questions, I promise. Send written notice, right? If they're late and they pay the late fee, you can still send a notice of default because late payment is a default. And you could technically evict them. I wouldn't recommend it. A single late payment that they actually paid along with fees, the judge is not likely going to grant you your eviction. But you may get to the point where you're 3 or 4 late payments in where a judge said, no, I agree, you're done. Even though you pay rent, you're not good at it. You breach your contract multiple times in the year. If they want you out, they can put you out. Right? And by sending these written notices, you may ultimately prevent an eviction, and both of you will be better off. They'll do better in the future because they know you're serious. And if they don't, well, there's always step 2. We'll get there. Inspection. Schedule your inspections well in advance. I like to tell landlords, before those keys are in their hands, you've already scheduled your first inspection. I recommend an inspection 3 months in and 9 months in. The 3 and the 9 of a 12-month lease. The first one is to make sure nothing crazy happens super fast. Because if it did, you're getting them out. The second one is to really test the waters. You've been here for 9 months. This place looks pretty good. Looks a little better than it was when I gave it to you. I want you to stay. Or, gosh, this place used to look so nice. I know for sure you are out. So you've got plenty of time to give the proper notices of termination and move on. Relist the place, get a better tenant. All right, so schedule well in advance, and don't take no for an answer. I don't know how many times landlords come up to me and say, Ernie, they just won't let me in. I tried so hard to inspect, or they asked me to go repair the AC, and when I got there, they slammed the door in my face. Don't take no for an answer. If you get a no, if you get the door slammed, don't go kicking the door down. That's also not a good idea. No shotguns, right? Don't go do that. But your lease probably has an explicit statement that assures a landlord of a right to inspect, to repair, to even show off the place to insurance adjusters or repair people or prospective tenants or buyers. And if they are denying you this, notice time. You are in default. And they say, well, look, here's the thing. I want to be there when you come in. I demand to be there. Listen, you can be accommodating and you can set that up with your tenant, but there's nothing in state law that requires it. Unless your lease says, and I will make sure you are there when I make this repair or conduct this inspection. State law doesn't require it. You are not bound by that. Don't let them hold your property hostage to their schedule. Your lease probably says something to the effect, I will first attempt to notify you, but I may enter even without notice. Read your lease. But I may enter even without notice to conduct a repair. Which means not I have to get your permission, or not that I have to schedule with you, but that at best I have to try to notify you. Which I recommend, and do it well in advance. but don't seek their permission. Unless somehow you gave them that right in the lease, you don't need to do that. Don't need to do it. Okay, and then last, always terminate in writing. If you mean to get somebody out and you mean not to renew, you got to send it, and you got to send it in advance. And know what your lease requires. Some of your leases require only 30 days written notice, boom, done. Some of them are slightly more complicated. Some say 60 days. Some say other weird things if they're finagled improperly. But if you don't know what your lease requires, you're likely to get it wrong. So always do it, and always do it in writing. This also is a bit counterintuitive. It's like, well, how can eviction be the fastest way to fix things? You're about to tell me how slow and cumbersome eviction can get, and I am going to tell you that eviction can be slow and can be cumbersome. But before we get there, I want to share a few facts with you. Most tenants, they don't want an eviction. Most tenants are nervous about the prospect of having this on their record. And so most tenants, you're going to find that once you filed, boom, they're out. They will go. That's most tenants. I didn't say all. Don't hold me to all. Most tenants don't want this, and they will do whatever it takes to not get an eviction judgment on their record. Most tenants don't actually show up. I go to these courts all the time, and it's default, 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 default. Whether it's in front of the justice court or on appeal in the county court, most do not show up to defend their claims. And the ones that do, half of them have no valid defense. Just none. They'll go and they'll tell a sad story. Oh, well, my job this, and oh, grandma that, and or the classic, there's mold in the shower. Like, come on, guys, that's mildew. It's in everybody's shower, right? Or they'll say something like, well, I asked for this repair, and so I withheld my rent. Not a defense. Not a valid defense. And so most don't show up to defend, and the ones who do just don't. This is to say that most evictions are actually pretty easy. For those of you who've done an eviction before, you probably have a 90% record of success. It's that 1 out of 10 where I get the phone call. Where like, Ernie, this guy is just a mess. He's asked for a jury. He's asked for discovery. I had this one, I'm dealing with one, where the defendant isn't even, I'm not going to say too much. The defendant has asked for each judge on each level to be recused. And this is a serious thing, and the judges have to take it seriously, so they send it up to an administrative judge, and the judge on the administrative level who reviews all these says, well, I don't see an instance where this judge has to be recused. So the administrative judge hands down. The guy sought to have the administrative judge recused, claiming bias and conspiracy and all these things. And all it does is it causes delay. And if you don't know how to deal with this, your head's going to explode, right? But this is so rare. It's just not common. I can tell you this story because out of 500 cases in the last couple of years, this one popped up, and it's kind of funny to some degree, not to my client. I hope you're not watching. Because it's just so odd. It's so odd. I once had a case where there were 6 constables in the courtroom because the judge and the entire staff was genuinely afraid of this tenant. 6 constables, the judge, everybody at a 15-foot distance. That judge said, I don't want this person here without 6 guns. It was nuts. Not common. Most people are not that nuts. You might think, well, my tenant's just crazy. They're not that crazy, I promise. Most situations are not that bad. Every once in a while it can get bad, and yes, it helps to have an attorney who can stand in your place. So, like I'm the one who's going to take the first shot, I guess. I'm a big guy. But most evictions just really aren't that complicated. Trials are over like that. If you've been to most cases, the judge asks a few questions, you're like, this and this and this. Okay, ruling for the plaintiff. You'll get possession in such and such a date, right? Just not that complicated. And then finally, most evictions are not appealed. That's not to say that there are none. I just revealed to you that a certain percentage, about 25% of cases do get appealed, even when the tenant didn't show up, right? Now that might just be, again, just additional layer of delay, but most cases end at the justice court. Most of those end without defense, and most of those are never filed because you threatened it and your tenant took you seriously. So can eviction be effective? Yes. The longer you wait, the bigger the problem it's going to be for you. Please recognize the following. An eviction is going to take about 30 to 45 days from the day you file it in the justice court. State law used to say, you better have this done, judge, in 21 days. Psst, that went right out the window with the pandemic. All right, so judges are no longer required to live by those limits. So 30 to 45 days is what's common these days in Harris County and across most counties in the state of Texas. Which means that even though you filed, nothing is going to happen quickly. There's a small chance that you're going to be in front of a judge in 2 weeks. Small chance. And if you are, good for you, but an appeal is possible. In 25% of cases, it'll be filed. So yes, there's a small chance that you're going to be done. You have your writ of possession in 3 weeks. That's possible. But you should have it in your mind that the eviction process is about 30 to 45 days, which is why if you're on day 7 and you send that notice to vacate, which is a 3-day notice, right? You're already a couple weeks in and you file, your math has to consider, I've only got 1 month on deposit, so I stand to lose 1 entire other month in this process. If they appeal and they have to pay a bond, you can maybe recover that, but assuming none of that, you want to limit your losses to just 1 month, which is to say, if you're going to wait a month before you even start the process, now you've lost 2 months. And if you're going to wait more than that, you've lost your shirt. It doesn't make sense to wait because the process takes at least a month and a half of time. Think of it in terms of lost rent. If you're charging $1,000 for rent, you've just set on fire $1,500 for the process. That doesn't include court costs and it doesn't include attorney's fees, which you may also never recover. So time is not on your side. You should use time as your barometer for speeding up the process, which is already slow. So don't delay a process that is made up of delay. Get on it fast. 7 days, notice to vacate, and then file it. When you're proving up your eviction, and you may have to, you're really just proving up 4 things. This is it. This is all that eviction is about. Can you prove these 4 things and you will win your eviction case? Is there an agreement? Well, if you don't have a lease, you might still have an agreement. You may say, well, no, we never actually signed anything. It's cool. Well, you have an agreement, right? Even an oral agreement is enforceable in the state of Texas. Rent in exchange for a place. That's all you need. What is that agreement? And so that's all you got to prove. If even you have an oral only agreement, that's your agreement. Rent in exchange for this place. Was there a breach of that agreement? That's where that good ledger comes in, right? Where you can pinpoint this is when rent stopped being paid. A clean ledger is excellent evidence of that, right? Notices that you sent out. Dog got out of the fence. Broken window. Kid drew all over the walls. Notice, right? That dog was an unauthorized pet. Grandma is now living there and she isn't on the lease. Unauthorized occupant. Notice. Was there a breach? These things are evidence of that. A clean ledger is your best bet because non-payment of rent is the overwhelmingly best evidence for an eviction matter. Other breaches, you're going to want to establish them with notices. Did the landlord send proper notice? Proper means Chapter 24 of the Texas Property Code. Because your lease may say, well, I can send notice by text, I can send notice by email, but the Texas Property Code doesn't say that's proper. The Texas Property Code may require something very different, and it usually does. When we are building a case for an eviction, for a landlord, the U.S. mail is our best bet for delivering notice. I'm going to give you the simple one. U.S. mail, one by regular and one by certified mail. So, but Ernie, the law doesn't require that I send 2 notices. That sounds like overkill. Well, I've never seen a landlord punished for too much notice, but I've seen many cases flush right down the toilet for insufficient notice. So, overkill or not, it's 60 cents for a stamp these days. You can afford it, I promise. So you send 1 certified and 1 regular. But you say, Ernie, listen, I don't even send that certified letter because they never pick them up. I don't know how many times I've sent certified mail, and that thing just comes right back to me. Irrelevant. That is irrelevant to the court. Get this. The law doesn't actually require them to get it. The law only requires that you sent it. Now, there are certain judges who want you to prove delivery, and that's why sending it certified is helpful. Because even if they never get that letter, what the U.S. Postal Service will give you is a report that says, on date such and such, delivery was first attempted. Right? They left a little note. Come to the post office and come get your letter. And here's what we know. If we sent a certified letter and a regular letter on the same day, and we know the certified letter was attempted on date X, logic shows us that the regular letter was delivered on that date, right? They were delivered simultaneously. This one was attempted. This one was definitely delivered. Your receipt from the USPS shows 1 regular, 1 certified. At least one of them got there. You nailed them. And that's day 0. You start your count, 1, 2, 3, file on day 4 or after, and you're good, right? And so that's the procedure that we recommend always. No judge has ever refuted delivery of proper notice when we sent it by regular and certified mail, and we can establish that delivery was attempted on date X. And then we based our filing on these facts. And then what are the damages? You are limited in an eviction. You may want to talk about unpaid deposits, and you may want to talk about the broken toilet fee, and you may want to talk about all the damage that they're doing to your walls. The HOA sent fee letters. Late fees have accumulated over the year. You can't claim any of that. Your damages are limited to 3 things. Unpaid rent, attorney's fees if you have them, and court costs. That's it. Unpaid rent, attorney fees if you have them, and court costs. If you have those, you can be awarded them. The last award that everybody's seeking in an eviction is possession. Eviction is not the end of the world. I'm a big advocate of resolution through settlement. And so once your eviction is filed, you don't necessarily need a judgment to get exactly what you want. Some of our best deals that we work out for landlords include settlements where we get unpaid rent, we get late fees, we get attorney's fees, and sometimes that ends up with a non-suit for that tenant. If the tenant comes through and gets us possession, we sometimes just dismiss the case against them and move on, right? Because our highest desire is for our landlord to be put in a position with minimal, or up to no loss in terms of the economics of the thing. But if you've gotten to an eviction judgment, you can establish a judgment lien on someone who is otherwise not interested in working something out, and perhaps recover in the future. So you can win your judgment and then abstract that judgment, and then let's say, for example, if you have the proper identifying information, and you should have the last 3 of their social, a date of birth, and the last 3 of their driver's license, which you will add to the abstract, you establish a judgment lien, and say 5, 7 years down the line, their economic situation is totally different. And now they're no longer renting, they're interested in buying a home. But guess who's got a judgment lien on them? You do. And guess what happens when the title company does a search on them? They tell them this lender is not going to loan you this money unless you clear this judgment lien. And then who gets a call? I do. So guess what? You have money coming your way. Tell us how you want to handle this. We draft up the release of judgment in exchange for payment, and the landlord gets paid at that time. It doesn't happen 100% of the time, but at the very least, this ends up on their credit, and if anything, it hopefully prevents a landlord who's doing research on this party in the future to avoid them. After an eviction appeal, you may have money waiting for you in the court's registry. If you've gotten all the way to the appeal, and if they paid into the court's registry, there may be funds that they use to get to that part of appeal. If you don't know how to get that money, you need to talk to somebody who can help you get those funds, because that's your money, right? You can also go to the court and say, hey, do I have money here? And sometimes they'll just give you a copy of an order that you filed with the court, and a check gets to you 6 to 8 weeks later, but it comes to you. It's your money, right? So the fact of an eviction, there might be some recovery for you. Make sure you know whether it's there and know how to get it. And then finally, every time you have some success utilizing eviction, you become better at it and likelier to use it to result in a much better outcome for you in the future. As a better landlord, you will create better tenants. You're going to start at the beginning, weeding out tenants who will never come into your property. You're going to manage your property in a way that even if you have to utilize an eviction, you can work things out where your losses are minimized, and maybe even a settlement transpires that eliminates all of your losses. And whenever you do have to go through judgment, you're going to get those judgments filed so that in the future, other landlords are put on notice of bad tenants, and maybe you're recovering years down the line with interest on a judgment that you won validly. Again, minimizing your losses and maximizing your profits.